All right, welcome to part 2 of chapter 11. So we left off last time discussing um, bad character and when it can be used and how it can be used, and that it should never be used to show because this person's a bad person, we should just convict them. And so prosecutors can demonstrate that bad character through impeachment, devaluing character when talking to witnesses, such as testing their knowledge of the defendant's reputation. And the prosecutor must act in good faith when they accuse somebody of committing a misdeed. In other words, this is just to make sure that there actually is a foundation or basis for this line of questioning. There are no set number of witnesses needed to prove good or bad character. A reasonable number of witnesses will be allowed on both sides to give the jury the ability to weigh and balance the evidence, and the witnesses they're going to prioritize and place belief in. Now, this will not be unlimited or indefinite. Okay. Now, prior sexual misconduct, Federal Rule 413 allows prosecutor in sexual assault cases to introduce the defendant's past uncharged sexual misconduct. Federal Rule 413 permits the introduction of uncharged incidents of child molestation in which the accused is charged with a current charge of that. And 415 makes evidence admissible in civil damages brought by victims of either sexual assault or child molestation. So if the person was sued and lost in a civil case, that can be used in a future criminal case. Now, we've talked about character of the defendant and how the prosecutor can challenge it, how the defendant can challenge it. The next topic is the character of the victim. So this is usually relevant in a homicide case, a self-defense case, or for a victim in a sexual offense case. When in homicide, it does not matter if the victim was good or bad person. Their character is generally unimportant. A murder is a murder, whether or not the victim was a good or bad person. So the prosecutor does not have to provide any evidence about the character of the deceased. Under 404A2B2, when an accused attacks the character of the victim, the door is opened to attack the character trait of the defendant. So if the defendant decides to attack the character of the victim, then the prosecutor can challenge the defendant's own character. Under self-defense, the character of the victim is relevant. It could be relevant because the person was afraid. It could also be relevant to demonstrate who the first aggressor was. So in a fight, sometimes maybe there is no direct evidence as to who started the fight. But if somebody has a bad reputation for being a hothead and for being violent and aggressive, that character evidence could be admissible towards whoever it is. And the defendant claims they killed in self-defense based on fear, then the defendant needs to show that they personally knew of aggressive behavior or aggressive character. Now, this does not have to be this long-standing thing. Like if you're at a bar, you meet a stranger, and they flash a knife at you and say, "Get out of my way so I can go to the bathroom first," and then later on there's a confrontation, that is a valid reason to be afraid, and that one incident can demonstrate a reasonable amount of fear towards this person. You know that they're armed, you know that they're aggressive, in a situation where most people are not aggressive. If the defendant's self-defense claim is that the victim is the first aggressor, then under 404A2B, the defendant can introduce evidence of bad character, even if they had no knowledge of it, in an effort to prove the deceased was the aggressor. So this would be the reputation of the community, even if the defendant had never met this person before. They don't have to know this is an aggressive person. They do need to demonstrate this person is aggressive and likely to be the aggressor, though. So that's why this evidence is relevant. Now, in sex offenses, historically, it was permitted to introduce the victim's past sexual history, but in the 80s and 90s, there has been reform here, and rape shield laws do prohibit some evidence of the victim's sexual conduct because it is not probative of whether or not they experienced a sexual assault on this day and time in question. There is an exception, though, where the past sexual relationships are relevant to prove that somebody else other than the defendant was the source of semen injury or other physical evidence. So if they can demonstrate, well, if this could be somebody else's, that's relevant. That sexual partner would be relevant, or partners. Evidence of other sexual acts between the victim and the defendant can also be used to show that the victim consented to the sexual conduct in question, or that the accused honestly but mistakenly believed the victim did consent. So this is essentially that there has been a past sexual relationship that was consensual. So this time the accused mistakenly believed that that relationship was still consensual. Evidence may be presented if its exclusion too would violate the defendant's constitutional rights to confront or subpoena witnesses. All right. State of mind of a homicide victim when the defendant claims self-defense or accident. When the defendant has been charged with homicide and they contended that it was an accident or in self-defense, the prosecutor can demonstrate that the victim was afraid, or the state of mind before they died. So there are times where the victim's state of mind can be relevant. It's again not to prove character, but to show that this wasn't an accident or that this was not self-defense. This is just kind of repeating what I just said to you. Character of a witness, universally across the board, character for untruthfulness can be used to attack a witness. The side opposing the witness needs to attack the truthfulness either through opinion or reputation evidence before rebuttal evidence can be introduced. So the prosecutor cannot preemptively introduce evidence of truthfulness. They do have to procedurally wait for the defense to attack the character, and then they can introduce a new witness to rebut that testimony. When the defendant is the witness, they do not have to take the stand, but if they choose to do so, they are a witness and their character for truthfulness does become an issue. So a prosecutor can raise tax fraud, embezzlement, these other things to show character here. The defendant's previous convictions that involve dishonesty or false statements do not have to be balanced. So prior other witnesses, we have that balancing test about probative value and prejudicial impact. Here under Federal Rule 609A2, it's automatically admissible as long as it is less than 10 years old. If it is 10 years or older, generally not admissible. All right, so that wraps up the video lectures for this chapter. Please reach out with questions or concerns.